Major breaking news, the Democrats have decided in Congress to wage an all-out assault on the attempt to remove suppressors from the National Firearms Act, arguing that to do so would violate in the Senate the so-called Byrd Rule. Let's break down why this argument by the Democrats fails. Hey folks, I'm Mark Smith, host of the Four Box Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, so I know there's a lot of other channels out there that have been doing an excellent job covering the whole issue about whether or not suppressors should come out of the NFA. I've done a couple videos, but there's some other people much more plugged in. I'm kind of deferring to them on a lot of this stuff and not getting in their way. But this particular issue is a little bit more in Mark's wheelhouse, and it's sort of complicated and sophisticated and geeky, and I need to step into the breach just to make sure this is nailed correctly, and I'm going to do that right here and right now for all of you. That is specifically that the anti-gunners in America and the Democrats in the Congress are arguing that suppressors may not be removed from the National Firearms Act by Congress now using the legislative process of reconciliation. We've talked about reconciliation before. Reconciliation is a specific budgetary process in the Congress that allows for taxing and mandatory spending rules to be changed by Congress without running the risk of getting held up by the United States Senate by the use of one of the parties deploying a filibuster. As you know, in the U.S. Senate, there's this procedural tool called the filibuster that when it's deployed means that you need 60, that would be 60 senators, to vote to close debate or close off and shut down the filibuster. And if you don't do that, there can be no vote in the U.S. Senate on pending legislation. There is an exception, however, to this general rule that gets around the possibility of filibuster. That's called the process of reconciliation, but it's very narrow, it's very focused, and reconciliation is designed for taxing and spending issues. How much the government taxes, how much the government spends, that can be done through the process of reconciliation. Now, because, and this is the key, because the National Firearms Act has long been understood, and we're going to give you the Supreme Court precedent on this in one moment, the National Firearms Act is a taxing and revenue scheme. Within that are things that are getting taxed, including suppressors, short barrel rifles, short barrel shotguns, and so on. The National Firearms Act is a taxation and revenue scheme. It is enacted by virtue of Congress's taxation powers. That makes it a tax. We're going to talk about that in just a minute. I'll give you the background, then we're going to cover the specific arguments that the Democrats in Congress are making. So what's going on here is that the Democrats wrote a letter claiming that the removal, listen carefully folks, it's very important to get this right. The Democrats are arguing that the removal of suppressors from the federal statute known as the National Firearms Act runs afoul of the so-called Byrd Rule, B-Y-R-D, named after Senator Byrd, because the Byrd Rule says that the process of reconciliation is fine, but the process of reconciliation may not be used to change substantive law. It cannot be used to change substantive law. It can only be used to change specific taxation and spending rules. It can't create like new laws that are substantive per se. If you try to do that, it violates the Byrd Rule, and the United States parliamentarian will rule that that particular aspect of the proposed bill violates the Byrd Rule, and therefore it must be pulled out of the reconciliation bill before it's voted on. And if it's not pulled out of the reconciliation bill before it's voted on, then the entire bill becomes subject to the 60-vote filibuster rule in the U.S. Senate, and the bill, in this case, the big, beautiful bill of Donald Trump's, would be held up. So the Democrats, in a desperate attempt to argue that suppressors should remain taxed and should remain a part of the National Firearms Act, just wrote a letter to the Senate arguing that this suppressor change violates the Byrd Rule. Here's what they say, and then I'm going to explain to you in detail why it's BS. Here's what they argue in their letter today. We write to urge you to strike a deeply dangerous provision regarding firearm silencers from H.R. 1, the fiscal year 2025 reconciliation bill recently approved by the U.S. House of Representatives on a party line vote. The provision, which would eliminate excise taxes on firearm silencers and remove their existing regulatory structure under the National Firearms Act, is extreme, reckless, and would undermine safety regulations that have existed for nearly a century. It goes on to say, as you know, the so-called Byrd Rule under the Congressional Budget Act makes clear that, in short, non-budgetary provisions cannot be included in reconciliation legislation. Removing the regulatory structure for firearm silencers is thus not only dangerous, but blatantly violative of the Byrd Rule. Put simply, the provision represents a clear attempt to make a significant policy change to a century-old law and cannot be adopted through the reconciliation process on that basis alone. So this is not a super shock. I expected them, and I think a lot of people at least understood the Democrats would try this ploy to argue that suppressors have to come out of the proposed big, beautiful bill that Donald Trump is pushing through Congress as best he can with Speaker Johnson and and Majority Leader Thune, and that's kind of where we are. So the question is, how strong is the Democrats' argument here? I think it's not very good at all. And I'm just going to give you the information that you can take with you to beat it up in your own way, doing whatever it is you do to help advance the Second Amendment. Specifically, you see, there is a United States Supreme Court case literally right on point that says that the National Firearms Act is a taxation and revenue scheme, period, full stop. And not only that, this Supreme Court case I'm going to give you from 1937 that explained that the National Firearms Act was constitutional because it fell within Congress's Article 1 under the U.S. Constitution power to tax. This Supreme Court case was actually reaffirmed as good law. That's right. Listen carefully. This is important, folks. It's very important. This Supreme Court case of Sunzinski versus the United States was affirmed as good law as recently as 2012 in the Obamacare case, where the U.S. Supreme Court upheld the Obamacare plan in a 5-4 decision. And in that decision of National Federation of Independent Businesses versus Sebelius, the Supreme Court relied upon the decision from 1937 of Sunzinski versus United States that literally said that the National Firearms Act is a tax, even though it may have some regulatory components to it. And we'll get to that in 1 second. So with that said, let's turn now to that Supreme Court case of 1937, Sunzinski versus the United States, which was, again, a challenge to the National Firearms Act, arguing, listen carefully, folks, because this literally destroys the anti-gun argument about suppressors getting pulled out of the NFA, violating the Byrd Rule. That's the allegation. Doesn't fly. Because here's the thing. The argument is that the reason why the suppressors are in the NFA is because it's part of a regulatory scheme. So what the Democrats are trying to do here is they're trying to make a fine distinction between the taxation power of the Congress and the regulation of suppressors. In other words, they're trying to separate the congressional power to tax suppressors within the NFA and separate that out from the power to regulate suppressors under the NFA. And they're trying to say these are two distinct things. And if you remove suppressors from the National Firearms Act using the process of reconciliation, you have to only do it after overcoming a filibuster, because the removal of the registration requirement of suppressors, right? You buy the suppressor, you got to get a tax stamp, you got to register the suppressor. The Democrats argue that the process of registration and those registration lists of the suppressors is a regulation, and that regulation cannot be changed by Congress using the process of reconciliation, because it's a regulatory, substantive legal change as opposed to a change in just taxation or spending. Now, that may have some good arguments, some appeal to it if you're a high school freshman on the debate team. However, there is a Supreme Court case on point that says that that attempt of a distinction between regulation and taxation doesn't work when it applies to the National Firearms Act. Why? Listen carefully, folks. Because the whole point of the National Firearms Act It's a revenue scheme. It's a taxation scheme. Incidental to, or kind of to support that taxation scheme, there are some regulations that go along with it, including the tax stamp and the registration requirements. But the only reason why the tax stamp and the registration requirements, the regulatory scheme of the NFA, is arguably or even conceivably constitutional in any respect is because it's derivative of and supportive of the taxation power, right? In other words, no taxation power means you have no authority under federal law to register suppressors or do fingerprints or do any of that stuff. It all stems from supporting or incidental to the taxation power. Now, this is just not Mark Smith saying this, although it's pretty obvious to Mark Smith in the four-box diner. This is the U.S. Supreme Court literally agreeing with me in 1937. And this decision, again, was reaffirmed in 2012 as good law. So this is not ancient history. It was done in 37, reaffirmed in 2012 by the Supreme Court. It's good law. Let's see what the case says in Sunzinski versus United States, and tell me if this sounds like this addresses and rebuts specifically the argument advanced by the Democrats. The court writes, quote, "In the exercise of its constitutional power to lay taxes, Congress may select the subjects of taxation, choosing some and omitting others. Its power to tax extends to the imposition of excise taxes upon the doing of business." The court goes on to say, quote, "Here, Section 2 contains no regulation other than the mere registration provisions." Hear what I just said, folks? Here, Section 2 of the National Firearms Act contains no regulation other than the mere registration provisions, which are obviously supportable as in aid of a revenue purpose. On its face, it is only a taxing measure, and we are asked to say that the tax, by virtue of its deterrent effect on the activities taxed, operates as a regulation which is beyond congressional power. However, every tax is in some measure regulatory. To some extent, it interposes an economic impediment to the activity taxed as compared with others not taxed. But a tax is not any the less a tax because it has a regulatory effect. And, the court goes on, it has long been established that an act of Congress which on its face purports to be an exercise of the taxing power is not only any less a tax just because the tax is burdensome or tends to restrict or suppress the thing taxed. So you hear what the Supreme Court just said there? It says that even though there's some regulatory components to the National Firearms Act, it doesn't matter. Because at the end of the day, this is a taxation and a revenue scheme enacted by Congress under its Article 2 taxation authority. And the mere fact that there are incidental regulatory effects derived from this tax doesn't change its nature. It's still just a tax. And the reason why that is important is because the Democrats' argument is literally opposite that. They're saying that if you take suppressors out of the National Firearms Act, you are altering the regulatory structure of gun control in America. And that's not allowed because the Byrd Amendment says you can't make substantive legal changes to statutes using the Byrd Amendment, meaning using the reconciliation process, getting around the filibuster. But again, the Supreme Court here says no. The regulatory effects of like registration and things like that are in aid of to support the essence of what's going on with the NFA, which is taxation. And because the essence of it is taxation and this other stuff is incidental, you can remove the taxation revenue component from the NFA and be perfectly fine. And to me, this makes clear under the Byrd rule that this does not violate the Byrd rule because the regulatory effect of registering suppressors, again, merely facilitates or supports the essence of the NFA, which is a taxation scheme. And the Supreme Court goes on to say in this case as follows. Here the annual tax of $200 is productive of some revenue. We are not free to speculate as to the motives which move Congress to impose it, or as to the extent to which it may operate to restrict the activities taxed, as it is not attended by an offensive regulation, and since it operates as a tax, it is within the national taxing power. Boom. Boom. The National Firearms Act is a tax. It's under Congress's taxation power. The reconciliation process, which allows you to pass taxing and spending rules without having to deal with the Democratic, in this case, the Democratic filibuster in the U.S. Senate, is perfectly fine. And any attempt by the Democrats to argue that the Byrd rule applies here is a no-go zone, because the Byrd rule says you can't make substantive changes to laws, but if those substantive changes to law, to the extent they allegedly exist, are attendant to or simply support a taxation arrangement, then they're not considered a problem. All right, folks, to sum it up, because of this 1937 case of Szynski versus the United States, which I'll put a link to it down below, which again was reaffirmed in Sebelius in 2012 by the U.S. Supreme Court, so still good law. In light of the language of that case, I don't see how the Democrats have a leg to stand on to argue that by pulling the suppressors out of the National Firearms Act, which again is a taxation scheme, somehow violates the Byrd rule, because if it violates the Byrd rule, of course, we can't do it. I mean, the Second Amendment community and the Republicans can't do it through the process of reconciliation. You'll go through a Democratic filibuster, and the Democrats will never allow this to pass. That's the reality of it. But the good news is, based on the Supreme Court precedent and the fact this is clearly a taxation and revenue scheme, I don't think there'll be a Byrd rule problem with any of the items in the National Firearms Act. And I think that applies also to the Short Act as well, because again, any of those items in the NFA are there legally only by virtue of the fact they're within a taxation and spending scheme, meaning a taxation and revenue scheme, which is constitutional under Article 1 of the Constitution, which allows Congress to tax things as a general matter. But again, that can be totally changed without running afoul of the so-called Byrd rule, and hopefully good things happen and we get suppressors knocked out, and hopefully the short barrel rifles and shotguns. But again, the history of the future has yet to be written. All right, folks, hope you enjoyed today's episode. Make sure you follow me on X at @4boxdiner. Don't forget to subscribe both to YouTube and to Rumble, and I look forward to talking to all of you real soon here at the 4 Boxes Diner.
Orders up. Table 2A.